Good day and welcome, and thanks for joining. Please like and share if this is helpful to you. I'm coming to you here today because it is my duty when I see such lawless, such illegal practices coming out of our judicial system. We all must take a stand and start sharing this information with each other. It is unthinkable, it's unconscionable that courts are doing this. And because we have been taught and programmed and conditioned through the public school system and through the corporations and through the government programming and through the media to shut up and don't speak our truth, to not ask questions and do as told. And we cannot do this anymore. What's going on in Madison County, Illinois court system, Third Judicial Circuit, is just really, it's crimes against America. So let's talk about what's going on here. I'm going to share with you the letter that I received, and then I'm going to walk you through what's it's alarming. Okay, so if you look at this letter, first of all, I've gotten, I don't know that you call a letter correspondence, but I've gotten letters from the court before. First of all, there's no seal. There's no indication that this is on, it's no letterhead. This is completely unprofessional. And normally the Patrick McRae is the clerk of the court, an elected official in Madison County, Illinois. And it says clerk of the circuit court, doesn't even say Third Judicial Circuit here. Doesn't give the address, doesn't give the website, doesn't give the phone number. There's so many things. It's usually centered on the letters that I get. So I don't know if someone just made this up, but a judge is backing this. That's even more alarming. Okay, so let's just decipher what this is, because today I want to show you that what this letter and why it's so important to me is because it's flawed. It's so completely disrespectful to mankind, to every single American, to every single living soul. This is a violation of due process. It's an obstruction of justice. It's a complete and total coercion and threat. And this is what they're doing. And they're doing it under the guise of the judicial system that's protecting them. They're getting away with something. If you and I did this, they would have us wrung and hung. And they would be like, well, that's not legal. Well, that's not lawful. And I'm going to show you why. So this is happening in America. What are we going to do? What are we doing about it? When you've got a judge who's like, I'm the judge in the black robe, satanic or whatever. And what are we going to continue to allow this? Seriously, if this isn't like, of course, I'm a little bit more charged from it. But the fact why I'm charged is because how many are sending these out? How many a day are they sending out? How many people are they taking complete and total advantage of and not even doing it? They're not even following the letter of the law that Patrick took an oath to. I have him on a recording, by the way, that says they took an oath to the Constitution. I don't know if it's filed because I know that the judges in Madison County didn't file theirs until I requested it. And so, that's a whole nother story. But let's look at this letter, okay, shall we? The letter, do you see a corporate seal? No. Do you see an address for them or for me? Nope. Oh, wait a minute. Today is July 2nd. I received this on June 28th. I guess they can see into the future. They're sending from the future because it has July 10th of 2025. That date hasn't even come yet. In fact, that date's another week away from when I received it. So it's dated in the future. And then Kathleen Ramsey, it doesn't say anything else here. Do you see a case number? What's this in reference to? This is called coercion. We're not going to tell you what it's for. We're just going to tell you that if you don't pay, we're not sending your file to the appellate court. And the appellate court ruled on a fee waiver, but the lower court is not following the appellate court rule. Oops. And a judge just confirmed they will not follow the appellate court. apparently they don't have to, because I mean, when you're making up the law and no one, I mean, who are you going to report a judge to? Another judge? See, they're all part of a club. They're all members of a club, and they're all like, hey, we got the total system, and we can just take advantage of every single person, not person, well, the persons, yes, living soul out there. Total disregard. Anyway, so our office, whose office? Because I don't see an office. I don't see where that's defined. Our office has completed preparing your record. I don't know who your is, and why I'm saying that is because we have been conditioned to read these contracts written by attorneys, and they are so flawed that whose are and who's your. This is a law of presumption and assumption, and assuming makes an ass out of you and me. So why I say that is because when I write a contract, I identify. So Kathleen Ramsey, I will call Kathleen throughout the document. Kathleen, we are preparing your record. Who's we? Kathleen, I would identify. Clerk of the court is preparing or clerk is preparing your record. And I would identify that throughout. That is the proper way to write anything, any contract you're signing. That's what I teach. And so our office, you're assuming there. And what the importance of that is, it's because when you assume, you're in their jurisdiction because you don't know who you are, you don't know who they are. Therefore, you're in a state of mind of confusion. And that's where you are a ward of the state. It's a state of mind. What state do you live in? I live in a state of conscious awareness of Christ consciousness. And I definitely don't live in a state called Illinois, because it's a state of mind of collective consciousness of tyrants, obviously. So let's keep going. Our office has completed preparing your record on appeal, which the appellate court waived fees. You, I don't know who you is. Are you? Because if I said you, then you would think you, right? So who's you? This is huge flaw in PMAs and all kinds of contracts. You have a balance due of $281 to be paid on before June 30th. I have to pay it before June 30th, but this is dated 7/10. So we can file your appeal. So they can file my appeal record with the appellate court. See right here, this is coercion. If you don't pay this $281, do you see a bill? Is this a bill? Because this doesn't look like a bill to me. Is this an invoice? It doesn't. What authority is this $281? So basically, let's just jump down here. Tina, did Tina sign this letter? Is there a signature? Do you see a signature? I don't see a signature. You know, everything is a contract, and there's elements of a contract. I even had one guy who took a year of law school tell me, oh, dual signature is not important. Dual signature is important, especially a one signature when you're making an offer. This is an offer to contract, and their offer is missing a lot of elements. What's Tina's title? I'm just supposed to pay Tina. Look, it says attention Tina or Juliana. So I'm just supposed to pay them because they sent me a letter. And I mean, if that works, can I send you a letter? Because I would like a couple thousand, 10, 20, 30, 40, 50. I mean, just start sending me. I'll just start sending out a bunch of letters exactly like this. And then maybe people will start paying me. Anyway, so $281 to be paid on or before June 30th. So we can file your appellate work. Tina doesn't give a title. Who's Tina? I don't know who Tina is. Is she the clerk? I mean, Patrick McRae, I know that he's the clerk of the court because I can look that up, and I've spoken to him and I have him on record. Says clerk of the circuit court. Doesn't say third judicial, does it? So Tina, we don't even know who Tina is, but Tina's not willing to sign here. That makes it kind of invalid. There's no case number. There's no citation of law. So we're making up a number. We're not telling you what authority this is on. We're just telling you that you're going to pay us $281. We're not going to, give you any evidence. And a judge ruled on this as I have to pay it. So please, which I don't have a copy of because they haven't given me a copy of. They want to charge me for a copy of the order that the judge did. Please come in. So I have to come in. It's a 45-minute drive. One way. And pay your balance of $281 with cash, or money order. Oh, wait. God. Oh, what's that Constitution? Oh, that Patrick McRae took an oath to, by the way. Article 1, Section 10, Clause 1, minor detail. No state, not some, no state shall make anything but gold and silver coin a tender in payment of debts. No, so I'm sorry, it says cash or money order. Huh, that's so funny. It does not say, I guess the Constitution changed and I wasn't aware of it. Congress passed that. Huh. Are you aware that Congress passed something that said cash and money order? Now, if I give cash, darn it, I don't have one with me. I posted it the other day. It says Federal Reserve note. I just posted something on Facebook about notes and how notes aren't really payable. So they want me to commit an illegal activity. Is that what I'm reading? In money order? Isn't that a note? That's not how the state, they do work for the state. It does say Madison County, Illinois. So that would be a state. That's a corporation, by the way. I'm not an employee of that corporation, although they would really like to make me one. I haven't accepted that contract. So cash or money order, so that we will have ample time to file. See, I don't file, I present, but file your record with the appellate court. Does that sound like an obstruction of justice to you? Or like they're not going to do it, even though everything that they're doing is, okay, let's go into some laws here. And then they tell me where I can send it to Madison County Circuit Clerk. Again, doesn't say the state of Illinois in there, does it? Who I can make it to. So there's no case number. There's no citation of law. There's no lawful invoice. There's no lawful order attached to this. Not that I saw, not when I sent it. There's no due date. It says on or before June 30th, but it's dated July 10th. So legalese is confusion. It's the devil's game, and they play it well in the court system. So we reason out, because we've been programmed and trained to reason out, okay, so they made an error, compute, and give them the benefit of the doubt. Are they giving us the benefit of the doubt? No. Are they giving mankind the benefit of the doubt, or are they taking advantage of mankind? Because to me, I don't know, this looks like they're taking advantage of mankind, all of us. And they're teaming up, because guess what? They took an oath. See, Patrick took an oath, the judges took an oath, the attorneys took an oath, and they're all, some of them, right? They not only took an oath to each other, and they're able to manipulate it. And then who are you going to report them to? The same team members that they're all on the same team. They're all working for each other. So who are we going to report them to? Supreme Court Justice? Oh, wait a minute. They all took an oath too. And not only that, but they're all part of a member called the bar. Not Patrick. Maybe he's not. But yeah, so this is interesting, isn't it? So no party is identified as a creditor or payee. It's not clear. So it's a bogus, coercive attempt to collect money from a living woman who has a valid fee waiver on record with the appellate court. The appellate court is the higher court and gave a fee waiver. And the lower court, Madison County, Illinois, Third Circuit, is literally, there's an order out there I haven't seen, but it was read to me on the phone, which I recorded. Did not quote a statute. It just said it doesn't meet the state statute, although the appellate court did. So I don't know. I'm not an attorney. So the higher court granted it. Lower court's not recognizing the higher court. I mean, I guess they could just make up rules. So this is not just a clerical error, by the way. It's systematic abuse. It's abuse to mankind. And are we going to keep allowing this? All of mankind are going around and paying this stuff. They get it in there. And I don't have the ability to pay this amount. This means tapping into my food source for my sons and I, because I barely make it every month, because I was let go for standing up to a bully and Pfizer and questioning them. repeatedly after I got policies changed and stuff, because we are supposed to question. We have a duty to question. We have a right, a God-given right that no one can take away. And it's time we assert these rights and start calling them out. Who can we go to? Well, we'll get to that in a minute. So let me just repeat. There's no lawful authority. There's no signed order that I've seen. There's no sign on this, whatever this is, because it's definitely not a bill or an invoice. It doesn't even have a case number or reference or address for the letter or I. And where's the fiduciary duty to? I mean, isn't the state a corporation for the public? So let's just go over here. And I don't know if I can, I don't think it's going to show. So the violations, I think, because I'm not an attorney, so I'm not giving legal advice, are 705. I wonder if I can stop share and then share this with you. Let me go here. And then let me go here. Just bear with me 1 second. Okay. I don't know if it is scroll or not. Let's just see. Okay. 705 Illinois Constitution, ILCS 105/2. Clerks are required to maintain and provide access to the court record. So I've been in there and couldn't get the court record unless I paid. I was being charged. Now, see, I get charged from the earth. And so if you're not, like, if you don't comprehend that we are all an electromagnetic field of energy and we are charged daily, just like our phones are charged and batteries are charged, we get charged. So the court system is mocking. Legal ease is the undoing of God's law. This is what I teach. So legal ease is undoing of God's law. So all of these statutes that I'm going to be quoting are undoing God's law. And so we are in this world. We're not of this world. In it, not of it. And when you invoke, which I have repeatedly in every single filing, 6 in May alone, several in June, numerous, I invoke laws of nature and nature's God, as stated in the Declaration of Independence and the powers of the earth. So I'm invoking that. Not only that, but I have a private agreement, and a private agreement stands higher than statutory. And in that private agreement, we have that its chancery court has subject matter and personam jurisdiction. I don't know, but I think maybe my ex being an attorney and hiring attorneys and the judge being an attorney and all swearing an oath to each other, I don't know, but it could be, maybe I'm being taken advantage of. Anyway, so second, clerks are required to maintain and provide access to court record. Okay, so that hasn't happened. And Article 1, Section 10 of the U.S. Constitution, and I'm going to go ahead and tell you that it's Clause 1, in there, what I just read to you, states cannot, not maybe, require anything but gold and silver coin as a tender, yet refuse lawful tender. I went in there with silver coins to the clerk, and Alyssa, the supervisor, refused it after she took it over the counter, accepted it, and walked away, came back 10 minutes later, gave it back to me and said that they could not accept that, and per policy, and that it was non-negotiable. I have that on a recording, non-negotiable, that they will not accept it, and that I could not see the policy. Then Patrick and I, on a recorded call with witnesses, says that they do have a policy that says they can't accept it, silver coin, and he was going to email me the policy. It's so weird that he hasn't emailed that. That was a week ago, and he still hasn't emailed that, although I followed up. I guess a FOIA request might take care of that, but boy, they just make it so hard on us, don't they? That's not coercion. UCC is Universal Commercial Code, section, that SS is section 3603 in paren B. It's a discharge of obligations by tender must be honored. So I offered silver coin and it was not honored. Does that put the judge that made the order in dishonor? Does that put Patrick in dishonor? I don't know, because I'm not an attorney, so what do I know? It means that us and mankind have a duty to start standing up. And I think the President of the United States, I think the Department of Justice, and I think that the Treasury and all those that do the 1099s and fund these courts need to take another look at the funding that they're giving out. Then there's 18 USC section 242, sorry about that. Deprivation of rights under color of law. Then there's 18 USC section 872, extortion by a public officer. Do you remember the letter? They're not going to do what? They're not going to send the record. They are refusing, withholding, obstructing, due process and obstruction. Fraud by omission, failure to disclose the terms of the alleged debt. Did you see where they were getting that authority from? $281. Where did that come from? See, I've already paid $75 and I don't even know why, but they told me, and I do have a court filing that's under duress that they told me that I had to pay $75 or they wouldn't send it to the appellate court. And so they were holding it. So it was under duress, and I did offer silver coin that day and they refused it. And I did offer the bond that's on file. I have a private bond on file. It's, there's this rule E in equity that once you put a bond on file, they're supposed to settle all accounting on that case within 72 hours. Funny, that didn't happen because I filed it February 28th and April 23rd and May 1st, I think May 19th, and again on June 23. Apparently they don't play by the rules. So denial of due process and equal access to remedy. Equal access to remedy. Does not look like that's happening, but what do I know? I'm not an attorney. And here's the kicker. The judge allows it. According to what was read to me, there's an order and the court sees it. They know it. They see this. They know it. And they do nothing. They know this. They have a duty to know this. There's this thing called honor. And honor is extremely important for judges, for our judicial system, for everyone, everywhere. And this is a complete and total disrespect, dishonor. And would I be off if I said this? It's intention to trespass on property by way of harm, by way of loss, by unlawful detainment of holding records, by extortion. I mean, does it seem that way to you? The entire system runs on presumed consent and on public ignorance. There's a maximum law that says ignorance of the law is no excuse. I pondered on that one for quite a while because there is not one man alive anywhere in the world that can know all of man-made legal. Not one man can know it all. And so ignorance of the law is no excuse means that it's God's law. And it would have to be simple. If ignorance of the law is no excuse, then that would be honor, no harm. It doesn't get any simpler than that. And that is the law. That's the laws of nature, and nature as God has stated in the Declaration of Independence. That's the basic law of mankind, honor and no harm. You see, as long as I do an honor and don't allow anyone to harm me, unless I choose that, it is my choice. But my sovereignty ends where yours begins. Hopefully I don't have to explain that. But this is not about one letter. It's not about just the letter that I received. It's about this is happening in courts across the United States of America. What have we become? What have we become? What have our courts just gone to? They're ignoring the very thing they took an oath to. And they're backing each other. This is alarming. This is scary. This is unthinkable, unconscionable. That they're being so blatant, because it's not just that. As they start to do smart cities and they've taken oaths to this whole new world order, we have to take back the reins and start holding these oath takers accountable. And this is about an entire model of judicial fraud, coercion, spiritual trespass. It's happening every single day in courts across the nation. It's color of law. And it's time to say no. It's time to put them in timeout. I mean, mankind is equal. It says it in the Constitution. It says it in the Declaration of Independence. It says it in the Bible. Mankind is all equal. And we are endowed by our Creator. That's in the Declaration of Independence, that we are endowed by our Creator. It says in the preamble, laws of nature, that there comes a time when we have to separate from being a person, a citizen, an entity that's really a sole proprietorship. Your name, Kathleen Acker Ramsey, is a name owned by the state. I'm not obviously that. That's a product. If you look up 410 ILCS 535.12, it gives you the definition of live birth. And that's a product extracted from the mother. That's what the live birth certificate, your certificate of live birth that your mom and dad signed. We can go into that later, but look that up. Anyway, so there comes a separation when we have to separate from the name and to our living soul. And it goes on to say, we hold these truths to be self-evident. Self-evident seems really evident that all of us are created equal and endowed by our Creator. So what I'm saying, and I say this all the time, is all those with titles are beneath us. They're our servants, because we're all equal. We're all equal. I don't care what your skin color is, or your political beliefs, or your religious beliefs, or anything. That's all BS, okay? That's all made up, man-made stuff to separate and divide us. Remember what legalese is, the undoing of God's law. So we're all equal. So when any president, judge, attorney, clerk, boss, manager takes on the role of a title, it's just a hat. They're just wearing a different hat, put on a different hat. Their first and foremost sacred duty is to mankind. Is it in honor of all mankind, and does it harm mankind? If it's not in honor, don't do it. If it's harming mankind, don't do it. The chemtrails, the poison, the letters like this, the total disregard for the man-made laws that they themselves have put into place. Then they go into their little shareholders and they want to make money. They want to send Junior to Princeton College. I think our assistant state's attorney had a video where he thanked all of Madison County for sending him to Princeton, and so that he could get his law degree, which was really nice of us. And they're mocking us. It's time to stop, because the next generation is watching, and we have a duty to stand up. See, when they take those oaths, when they take that title, they step down. They're like, hey, I know that I have this sacred duty. It's a sacred duty to protect mankind. And I'm going to take this high title on as a judge, as attorney, as a CEO, a CFO, a COO, as a board member, as a shareholder. And whatever I do, I know that I must be in honor and do no harm. And all mankind is to hold them accountable. It's time we take on our duty and start putting them in timeout, don't you think? Because I do not consent to this. I do not. I do not comply. And I will not be silent. My name is owned by the state. My soul is Creator's. And Creator has given me the sacred duty to speak my truth and be authentic and share with you, as it is my duty, as I stand in truth, as I stand for remedy, for peace, and for all, because I've had enough, and I hope that you have too. Anyway, I hope this is helpful. Please like and share. And until next time, roll the dice and play the game of life.